changes that his mother can handle those?
Yes, I just don't understand how it would mean I would have to co-parent with her.
Well, it just means to be present to allow the transfers, the exchanges.
Right.
So it'd still be at 5 o'clock though?
Yes.
All right, so real quick, Ms. King, please raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I swear. I do.
And you're agreeing to stipulate to, in the summer parenting time, to amend the exchange date from Sunday at 5 to Friday at 5, is that correct?
Yes.
And you understand that, due to the work schedule, it might be Mr. Evilspizer's mother that's handling those exchanges. And that does not mean the exchanges should not happen if his mother shows up to do the exchange. Do you understand that?
Yep.
And you're in agreement with that change?
Yes.
Thank you. And sir, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And sir, you're also asking the court then to amend that change, that summer parenting time would be week on, week off, exchanges on Friday at 5 o'clock instead of Sunday, is that correct?
Yes.
And you're also in agreement then that your mother can also handle the transportation and exchanges for those parenting time exchanges?
Yes.
And for the record, what is your mother's name?
Angela Evilsizer.
Okay. The next tricky question becomes, what are we doing about the next exchange? Who's got the child currently?
I do.
All right, so Friday, the 17th, she'd be going to dad?
Is that this weekend?
Yes, 17th is Friday.
Yes, I'm fine with that.
All right, so exchanges are changed to Friday, beginning this Friday, July 17th. So you'll meet Friday, July 17th at 5 p.m. for the exchange, and it'll be Fridays throughout the rest of the summer.
Perfect. Is this an order that extends like other summers or just this summer?
Well, this is what you want to do every summer, correct?
Correct.
All right. You agree with that, sir? This is just the summer parenting time for now on will be Fridays at 5.
Yeah, that's fine.
Okay. All right. Thank you to the two of you for working together to resolve it. We will prepare that document. The exchange will be this Friday at 5 o'clock and then Fridays moving forward. Thank you.
Thank you.
All right. So we have Ms. Schoolcraft present. Do we have Mr. Smoker Moore present?
Can you hear me? I'm right here.
You're Mr. Smoker Moore?
Mr. Smoker right here, yes.
Thank you. All right, so I'll call the case then of Keegan Smoker Moore versus Kaylee Schoolcraft, file number 19-17839 DC. The parties are present, and Ms. Schoolcraft, these are your motions. What are you looking to change?
I'm looking to change to go to 50-50 for equal parenting rights for me and Keegan, for Leo.
Okay. What is the current schedule?
The current schedule is Keegan has 60-40, so he has a primary speed. And I'm wanting to get that back to 50-50.
All right, you broke up a little bit, so what's the exchange? How do you guys handle parenting time?
So he has Leo for 2 weeks, and then he will bring him to me for 1 week, and we will go about the 2 weeks in 1 week. I'm looking to have it for 2 weeks on and then 2 weeks off for equal.
Okay. And sir, are you in agreement or disagreement?
I'm in a disagreement with that. I agree with having 1 week, 1 week off. I feel like it would be.
This is new.
All right, man, he gave you every opportunity to speak without interrupting, so you're gonna do the same.
That's my apologies. I thought I was on mute.
All right, go ahead, sir.
I believe we should have 1 week and 1 week off with Leo. It would be better. we'll be better off when, school starts, and it'll be a better consistent schedule besides having a 2 week on and 2 week off, in my opinion, right there.
All right, so you're willing to change though to the joint physical and just do it on a week on, week off exchange, okay? Is that correct?
Yes.
Okay. All right, Mrs. Schoolcraft, you can unmute. And
Sorry,
let me know if you,
I guess I'm confused on what that means. So is he saying like 1 week off, 1 week on for 50/50, or is he not wanting to change the 50/50?
no, he's saying week on, week off is my understanding. So you'd have him for a week, he'd have him for a week, and then you just keep repeating. So it is back, it is 50/50. It's just a week at a time instead of a 2 week block.
Right. That's all I wanted to try and understand. Yeah, I'm okay with that. I'm comfortable with that. As long as it's equal parenting for Leo and having equal time with both parents.
All right. So sir, what day do you think you guys would exchange?
Her week was started Sunday, and I would be getting him back this Sunday. But I would also
Okay.
like to change some of the transportation as well.
All right, so you want to exchange on Sundays. What time do you guys usually exchange?
3.
Okay. And how are you doing the exchanges? Are you meeting somewhere? Is one parent dropping off? What's the situation?
In my custody, I would always have in the paperwork, I would always pick them up and drop them off at mom's. I would like to change it to the police station and do a pickup drop off there instead. Safer for the both of us.
All right. Ma'am, do you have any objection to the exchanges happening at a?
I do have an objection. We started this custody agreement when I moved down to Cadillac. That's the only reason why he got awarded the 60/40 was because of the distance. The only reason why he has the arrangements for him to be the primary pickup and drop off was because I did not have a vehicle when he first established
Let's talk about then what you think the appropriate exchange should be. How do you think it should?
That's where I'm getting to. I had written down in the motion that because Keegan has been being the primary pickup and drop off, I was wanting to have it to where Keegan drops him off to my weeks and I drop him off to Keegan's weeks. But if he's wanting to change that to the police station, I would still want me to be dropping him off to Keegan and then vice versa, Keegan dropping him off to me.
All right, so you're willing to share the exchanges, but you don't want to meet at a police station, correct?
I don't think that it's necessary. We never have any problems with pickup and drop off. There has never been any kind
Ma'am,
of.
I ask
No
very
problems.
simple
He dropped me.
questions that can be answered with a yes or no. I don't need a full explanation.
Oh,
I
I'm
was just
sorry.
asking
I'm
if you're willing to share the, Miss Schoolcraft,
Yes.
just take some time and relax. Let's not talk over each other. So you're willing to share transportation, but you just don't want to meet at a police station, correct?
Yes.
Okay. So, sir, why do you feel it's necessary to meet at a police station?
Well, I've been using my girlfriend's car and she's been always with me, and she's always been having a problem with that, and every time I get them, we always get in an argument about something later on about that, and she's threatened her before, and she already had, her boyfriend had a restraining order out on my brother when he lived here at the time, and I would rather feel comfortable and safer just meeting there and just exchanging there.
All right, but you've been doing exchanges currently, you've been doing the drop off and pick up at her house, is that correct?
Yes, I've been doing that.
Well, I don't really see a need to involve a police station exchange. I mean, typically the standard is that the receiving parent does the exchange. So when someone's parenting time starts, they go to pick up. Then their other parents' parenting time starts, they go to pick up. That usually works best because then you're not relying on someone dropping the child off to you when your time starts. So the parent whose parenting time starts is kind of the one to make sure things are happening on time and not relying on the other parent. Sir, do you see any real issue if it is that the receiving parent picks up from the other parent?
I'd still feel be more comfortable just picking them up and dropping them off myself and all that.
All right, because earlier you said you wanted to address the exchanges, but you're willing to keep the exchanges the same. All right, so what I'm getting then is that we would exchange the parenting time, just the schedule, so it would be every other week, week on, week off schedule. Exchanges Sundays at 3. And it would remain that Mr. Smoker Moore does the pickup and drop off. Is that correct, sir?
Yes.
And Ms. Schoolcraft, do you have any issue with that agreement?
I do. I don't see why I can't deliver my son to Keegan on his days and why Keegan has to do the pickup and
No
drop.
problem.
off.
If there's no agreement, then what we'll do is we'll set all the matters for a evidentiary hearing.
No, I will agree with it. I'm not comfortable with it, but I will agree with it because that is how it has been going for the last couple of years and there has been no issues. So I am okay with keeping it like that.
All right. All right, so if the parties are okay with that, we can make that change. Just real quick, I'll have each of you state that on the record after I put you under oath. So I'll start with you first, sir, since you're the plaintiff. Would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do, yes, sir.
And sir, is it correct that you're stipulating and asking in the court to change the order that the parties would continue to have joint legal custody, and then the parties would now have joint physical custody with a week on, week off parenting time schedule, exchanges on Sundays at 3 p.m., and that you would do the drop off and pick up at Miss Schoolcraft's residence. Is that correct?
Yes, sir.
All right, and are you making this decision freely and voluntarily?
Yes, sir.
What do you guys do for holiday parenting time? Do you follow the standard holiday schedule?
Yes, sometimes if I had them for Christmas, then next year she'll have them for Christmas, vice versa.
All right. Ms. Schoolcraft, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And ma'am, are you also asking this court then to enter a stipulated order granting the parties joint legal and joint physical custody, parenting time to be week on, week off, exchanges Sundays at 3, and Mr. Smoker Moore will do the drop off and pick up at your residence. Is that correct?
Yes.
Yep. And do you, as to holidays, do you guys follow a standard holiday schedule or you just kind of work it out on your own?
We just want to work it out on our own, kind of like what he just said. Normally with major holidays, if he has them one year, I'll have them the next. But sometimes if we don't do a certain holiday, like he doesn't celebrate New Year's, I'll have them every New Year's, kind of like that kind of thing.
All right, so we won't make any changes to the holiday parenting time because the parties have that worked out between the two of them. This would impact potentially the support. So there would be a new support recommendation based on equal overnights. Any questions, Mr. Smoker Moore?
With support, like how would that go? Because I am paying a $2,000 medical bill right now for him, and I'm just curious on how that's going for him and how that will go for both parties.
Well, there's a percentage that people have to pay for any uninsured medical expenses. So that
I got
currently looks like a
Leo.
basic.
Sorry, that's something. I'm not on mute. Let me fix that.
So based on your last order, there is an order that says, looks like that she pays you $38 a month. And then if there's ordinary medical expenses above and beyond the $200, that the parties pay percentages for that. So that's how medical bills are addressed. If you have paid a medical bill and she owes you a certain percentage, you ask her to pay that. If she doesn't pay it, then you can seek the friend of the court's assistance. But a new support recommendation will be prepared because this does change the ordinance. Any other questions, sir?
No.
And Ms. Schoolcraft, any questions?
No, sir.
All right, thank you both for appearing and working together. You are free to sign off and we'll send you that revised order. Thank you. Looks like we might have the parties present on the Klein matter. So the court will call the matter of Brian Klein versus Lindsay Klein, file number 26-20422 DM. Mr. Klein, can you unmute? Let me know if you can hear me okay.
Good morning, Your Honor. I can hear you just fine.
Thank you. And then Ms. Bailey Quick, your appearance, please.
Thank you, Miranda Bailey Quick on behalf of Lindsay Klein, who's present with me.
All right, thank you. This is an initial hearing to address custody, parenting time, and support. Ms. Bailey Quick, do the parties have any agreements on those issues?
Your Honor, I've not had an opportunity to talk with Mr. Klein. I know the parties have communicated some about it, but perhaps this would be a good opportunity for a mediation referral so we can reach any resolutions. I believe that there will be a resolution.
Okay. Mr. Klein, any issue with going to mediation to see if you guys can reach an agreement?
Not at all, Your Honor.
All right, then we'll do a referral to community mediation, set the matter for a status conference after that mediation to see if there's an agreement. If there's not, that's fine. Then we would just set the matter for an evidentiary hearing. And if there's an agreement, we can just make that the order. Any questions, Mr. Klein?
I do have a question. Are children supposed to be allowed for court by chance?
What do you mean be allowed for court?
Well, so our daughter is at the lawyer's office, and I wasn't sure if that was a okay thing to have or not.
All right, well, I don't see her in a courtroom, so usually we don't have them participate in the courtroom.
Okay,
If she's somewhere in the office, I don't see any issue with that.
perfect. I just want to make sure we're good.
Anything additional, Ms. Bailey Quick?
No, Your Honor, I would just ask approximately how long from now that the court is planning on setting a continued hearing.
Probably in about 60 days, 45 to 60.
Okay, great. Thank you. Just to plan accordingly. I appreciate it.
Thank you. You're all set.
Thanks. Bye-bye.
Court next call the matter of Michelle Brown versus James Frederick, file number 18-17541DS. Do we have the parties on that matter present?
Yes, sir. Mr. Frederick is here.
All right, thank you.
I am Michelle Brown.
All right, thank you, Ms. Brown. And Ms. Brown, this is your motion to change domicile, is that correct?
Yes.
All right, and you're asking to move to where?
To Florida.
Okay. And you have sole legal and sole physical custody, is that correct?
Yes, with no visitations unless by my choice.
All right, we're on the
Mr.
record in
Frederick,
council
are
number
you
DF
opposed to her
240493.
move?
Yes, sir, I am. I've been trying to get in contact with them for a couple years now. She doesn't answer my phone calls or anything like that. I haven't had their address. They still gave the address. It's a P.O. box in Rosebush, not their actual address in Mount Pleasant. You know, it's hard enough for me to get out there because you guys took my license to see them. And how am I supposed to be able to go all the way to Florida to see my own daughters? You know, I haven't even got to have my youngest by myself for over an hour. I mean, she
Well,
didn't
what motions have you filed to get some type of specific parenting time schedule?
I honestly none, because I don't know what I'm doing.
Okay. I see back in 2019, mom was given sole legal, sole physical custody. Parenting time was set as the parties agreed.
Yeah, and another thing with that is we had a case 6 months prior to this one in Roscommon County where they gave us joint custody and that. And she's like, oh, we're going to work it out. So I dropped everything in Roscommon and then went to Florida to work for a little while. And she left me, then told me she was pregnant with my youngest daughter. And since then, I haven't, you know, been able to see her or anything.
Well, I mean, you certainly were always free in his last 7 years to file a motion for specific parenting time. There's a statute that says if somebody files a motion for specific parenting time, a court shall consider that. And we always do, and we would set out a schedule. But if it's not done, there's not much that can be done by the court. We can't proactively go out there and file motions for you. That's your job to do. Child,
I
it
understand.
hasn't happened. So I guess I'm confused why the big opposition if you're not exercising parenting time anyways. Last time you saw-
The 23rd, and that's because April 23rd, I believe it was, my daughter's talent show. And that's because my daughter reached out to me to
Just to
invite
be
me
clear,
there.
this is
I mean, they talk to my mom and dad all the time, and they get to see my mom and dad, and Michelle talks to them, but I can never get a response out of her. She just had another kid not even 6 months ago, and I don't know how she's just going to leave state with that one.
Ms. Brown, roughly when are you looking to move?
Towards the end of August. I was pushing for the beginning of August, but towards the end of August is what the game plan was, if I get a yes.
Well, I don't have if it's a contested hearing, I have to hear some testimony and take some arguments. I don't have a hearing date until September 23rd. I mean, the big
Okay.
issue is what is his parenting time schedule going to be? If he's seeking a specific parenting time schedule, then I need to consider that. So
I would love to have my daughters.
it's likely, ma'am, given your sole legal custody, that the move itself would be granted, but then the next question becomes, what is his parenting time schedule going to be and how are we going to make that happen? And again, I don't know what his history and relationship is like with the children, because that certainly hasn't, is there one child or two?
Those two.
There is two.
My oldest, I try to have as much as contact as I can with her. You know, when I do go over to my mom and dad's, my nephew is playing with my youngest daughter on the phone, so I'll talk to her every now and then on that. But my oldest was the one I used to talk to the most, and I haven't talked to her in 3 months, but I guess her phone broke.
All right, and so ma'am,
Yes.
what are the primary reasons for the move? Do you have a job lined up? Do you have family? What's going on?
I have a job that I am going to be applying for because I am currently in college for a bachelor's degree in business administration with international concentration international relations. And I just seen more fitting to be in an import outport in Florida for better jobs for what I'm going for.
All right. Do you see any major issue if we have this hearing on September 23rd?
No.
So we're gonna set the matter then for a evidentiary hearing on September 23rd at 11 a.m. That is a in-person hearing. Parties need to file any witness and exhibit lists that they wish to have 21 days prior, as well as the court would interview the children. So whoever has the children that day needs to have them here at 10:45 for the child preference interview.
Okay.
Any questions, sir?
Yeah, what's all gonna happen at that court date, sir?
We're gonna take
I don't-
testimony from the police and hear everybody's arguments and make a decision.
All right. Okie dokie.
Any questions, Ms. Brown?
No, that's it.
All right, you guys will get notice for that hearing. We'll see you here on September 23rd.
All right, next up we have Michael Bodnar Ventures versus Quality Container Buildings.
Yes, Your Honor. Ira Bowman is here with my associate Samantha Baines and also Mr. Bodnar himself. We are here for a default prove-up. Depending on how badly I fault this and mess up, it takes 10 minutes maybe.
Okay, you need a record?
I think it's prudent, yes.
Okay. Thank you. All right, next up we have Douglas versus Zymera.
Yes, Your Honor, this is Tania Godinez for the defendant. We believe it'll take about 30 minutes and we do need a record, please.
Okay. Anyone else here on that?
I believe
Yes,
Mr. Douglas.
Yes, Your Honor. I'm Andre Douglas, the pro se plaintiff, and I agree with Ms. Godinez. I would like a record for the hearing.
Okay, great. Thank you.
I believe it'll take about 30 minutes.
Sure. Okay, thanks. All right, next up we have Staybar versus CBRE et al.
Erin Hamilton for the plaintiffs. And I believe we've got Megan Crow, Rhonda Payne, and Deb Greenleaf on the call as well for defendant. And 30 minutes, I believe will be appropriate, Your Honor.
Okay.
Yep, Rhonda Payne for CBRE. I think 15 minutes for our part.
Your Honor, this is Deb Greenleaf for CSHV or Hill Country Galleria, and for me, it will be about 15 minutes.
Okay, the hearing's set for 30 minutes, so time will be allotted 15 for the movement, 15 for the respondents.
Your Honor, Megan Crow here, and I'm just observing on behalf of my client.
Okay. Anybody need a record on the motion to compel?
Yes, Your Honor.
Yes, please. Thank you.
All right, thank you. Okay, next up we have Ryder Integrated Logistics versus Diaz.
Your Honor, this is Aguila Valderrama with the plaintiff, Ryder Integrated Logistics. It's for a motion for default, so maybe 15 minutes, 10 to 15 minutes, and a record is necessary.
Okay,
Thank you.
thank you. All right, last on the list for the morning docket is Darcy versus Ellison.
Yes, Your Honor. It's defendant's motion for continuance. This is Ann Knight for the defendants. And I think we had said 30 minutes, but I think probably 15 would be sufficient unless opposing counsel disagrees.
Yeah, Robert Morse for the plaintiff. It is no longer opposed, Judge. So I think that 15 minutes just shrunk down to maybe 120 seconds.
Okay. Well, why don't I do this since y'all are at the end of the docket? I don't want to unnecessarily take up your time. Well, let me tell you a couple of things. You filed a docket control order. It said you had a trial date. You didn't contact court administration to set a trial date. You are not set for trial. Therefore, I do not need to grant a continuance. So what you need to do is identify a new trial date. And once you've identified that, contact court admin and get it set with them. Sound good?
Sounds good, Your Honor.
Sounds
Yes.
good. Thank you,
Thank
Judge.
you.
All right. Yeah, just refer our local rules 1.8 and 2.3 talk about setting a case for trial.
Okay.
And it always, unless you're specially assigned to a particular judge, which you probably aren't, you need to contact court admin and they will get you on a jury docket. Okay?
Thank you, Judge.
All right.
May
You're
we
free
be
to go?
excused?
Yes.
Thank
Take
you.
care.
You too.
All right. Here's what we're going to do. We're going to go back to the top of the docket, which is the Amplify Credit Union versus Jackson case. So if you're here on that case, remain in the virtual courtroom. If you're here on some other case, I would just like you to please turn your video off so that I'm only looking at the folks here on the current hearing. We will take the cases in the order that they were called, so just please be patient. We will be back with you. All right. We are here on cause number GN 26-003321, Amplify Credit Union versus Jackson and Kralev. Let's start with announcements for the record, please.
Stephanie Schwab of Naaman Howell on behalf of petitioner Amplify Credit Union.
Ishmael Jackson, pro se, Your Honor.
Okay. All right. And Ms. Schwab, it's your motion, so you may proceed.
Thank you, Judge. This is a application for expedited foreclosure under Texas Rule of Civil Procedure 736. This is in regards to a Texas home equity loan. It was executed in 2021, October of 2021 by Peter Kralev. The deed of trust on that, so that is a secured, that's the note. It is secured by a deed of trust. The deed of trust is executed by Peter Kralev and his spouse at the time, Mr. Ishmael Jackson, who were the owners of the property. Both of those documents are attached to our application for expedited order and are supported by the affidavit on behalf of Amplify Credit Union, establishing those are true and correct copies of those documents. The deed of trust is also recorded in the official public records of Travis County. The recording information is provided on that copy. There has been a default in the payment of that loan. The records of Amplify Credit Union, so that affidavit sets out payments starting with December's 2025 payment and to the present have not been made. In our motion regarding this hearing, requesting the court to issue the order allowing the foreclosure, again, there's an additional affidavit from Amplify Credit Union further stating that that is still in default. There have not been any payments made on that loan since November of 2025. And in that motion, we have actually attached a copy of the payment history for that loan. There's a couple exhibits that we have added to the box for the court to look at. Mr. Jackson has filed an answer in this case. That answer kind of lists the laundry list from the statute of the various defenses a party can make. Some of those not particularly applicable. This is the original note in deed of trust were to Amplify. So they are the original lien holder on that. So no, issues, transfer and holder and any of that. It talks about the service. Well, he's appeared. He's filed an answer. He's here. So whatever defects might have been in service are not really going to be applicable anymore. We don't, admit to that. They were served by the clerk as pursuant to the statute. Mr. Kralev has not filed an answer. We have been in contact with him. He is knowledgeable of this, has expressed has no intention to contest this foreclosure. as far as notice of the debt, that was one of the issues raised in the answer. Under the note, the terms of the note, notice is to be sent to the property address or such other address as the borrower might provide. In our initial application for foreclosure, we have the, which I think is Exhibit 1 in the box there, has our notice of default that was sent from my office on March 4th, 2026. You can see that is sent to the address for the property, that 11103 Balcones Wood Circle. Mr. Kralov at some point prior to this default had updated an address to that Swearengin Drive, so we actually sent it to both. We understand that Mr. Jackson is not living at the property currently and hasn't for several months now, but he never provided us his updated address. We got it once he filed his answer, and so since then we have been providing notices in the proceeding to him at that updated address, but prior to that, we followed the note requirements, which said to send it to the property address. There's been some in the answer that he's either didn't authorize the debt, not obligated on the debt. I will note the note was only signed by Mr. Kralov, but the deed of trust is signed by both of them. We attached in our motion for this hearing some of the documents from the closing, one of those specifically being the driver's licenses that they were collected at closing, showing who signed that deed of trust. One of those is Mr. Jackson, evidencing his consent to the deed of trust or the lien. I would also note, because it's a home equity, it's a non-recourse debt. So the purpose of this proceeding is just to foreclose on the property. We are not seeking a judgment on the debt against anyone. We're just seeking to exercise our lien rights because the debt has not been paid. Some of the other exhibits we've included, one of those is specifically the divorce. So Mr. Kralov and Mr. Jackson have been divorced. That was finalized last year in 2025 here in Travis County. And I attached a redacted version of the divorce. I redacted out most of it because most of it's not relevant. But the specific portions that are, I get the page numbers there. Page 25 is where the property was awarded to Mr. Jackson in that divorce. And then page 28 and 29, where he assumes the debt on that property, which is this note and lien. This divorce was pursuant to a mediated settlement agreement, meaning he agreed to those terms. There was an appeal made on the divorce decree. That appeal is now final. It was dismissed by the Court of Appeals. So there is no further appeal can be made on this divorce decree. I know there are other appeals going on regarding some enforcement issues of the decree, but none of that is relevant to whether this debt or this lien should be foreclosed on. Some of the other exhibits I attached, I did attach a couple of the orders from those enforcement. And really, specifically that Exhibit 7, the reason I attached that one is because there's been, again, this issue of notice, whether Mr. Jackson has received notice from Amplify about this debt. This was from November of 2025, one of these enforcement actions on the divorce decree, where Mr. Jackson was actually able to log into the account for this loan in the courtroom and was able to, gain access to that in November of 2025 through, I think, his phone app. And so if he wanted to update his address with Amplify or otherwise get information on the loan, he had the ability to do that, and that was demonstrated to the divorce court. And then again, the other order just again showing that he's not making the payments on the loan. I think Mr. Kralov was making them for a while, and then my understanding is he did stop that. And so I know there's a lot of things back and forth between the two of them about who's supposed to be paying what and who's able to pay what and for what reasons, all of that. None of that is relevant to enforcement of this deed of trust. That's between the two of them. If Amplify is not paid on its loan, it's entitled to enforce its lien, and that's what we are here for today. Mr. Jackson had reached out to us about, extending this hearing because of some enforcement actions he's got going on. We haven't been paid since November. We need to get this resolved. We need to proceed with the foreclosure. The debt's not been paid. So that is kind of just the sum of our position on that. And so we're asking the court to sign the order allowing us to proceed with foreclosure of the lien.
Okay. All right, Mr. Jackson, I'm going to turn it over to you, but before you proceed, I'm going to swear you in since you're telling me his testimony. Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, go ahead.
Thank you, Your Honor. There are several things or speculations that former opposing counsel mentioned that I'd like to correct. But prior to that, Your Honor, before we reach the merit, I asked the court to address Texas Rule 736.11 and alternatively request for continuance. I did reach out to opposing counsel for continuance, and it had nothing to do with enforcement actions. I'll try to keep it relevant to this. As you know, this has been a journey. We've met before in an associated case. Cause number C1C4 CV 25002373 is a separate original civil proceeding, which was filed in April of 2025, more than 1 year before today's hearing and before Amplify filed this Rule 36 application. The original verified petition expressly alleged fraudulently refinanced, jointly controlled property. Mr. Kroloff is alleged, and forgive me, I'm pro se, I'm trying to do this correct, alleged it was discovered to have, what I'm alleging to fraudulently have refinanced a property that we as single, not a married couple. We bought this prior to marriage. We both invested in it. I held a vested interest. He concealed the transaction, controlled the financial records necessary for me to discover and investigate it, hence the ongoing post-divorce issues and the current appeals before the Third Court of Appeals related to that MSA, which opposing counsel mentioned, and the very divorce decree. The divorce decree was not that appeal dismissed. However, the nunc pro tunc was allowed, given that there were some unauthorized deviations within that. But again, I'm trying to keep it narrowly focused on this issue. The current First Amendment original petition, which was filed in May 19, 2026, continues to allege the false and misleading representations concerning refinancing, fraudulently concealing it, solely controlling all contact points with the lender, Amplify, who I've been in contact with as much as I legally could. My name is not on the note, as opposing counsel mentioned. I am not a party on that note. And as far as the deed of trust, that had nothing to do with the refinancing. The deed of trust was for another, and that driver's license was another correction on the deed that was somehow attached to this, hence the allegations of fraud, which, again, that's the civil case that I mentioned before. I could not identify Amplify's precise instruments at that time or position earlier because Kroloff controlled the complete mortgage account. As opposing counsel could note, I had no access to it. When on November 20th of 2025, the court ordered him to give me access in a hearing in which it, within 1 week later, stripped that very property through a writ which violated our divorce decree and MSA, hence the appeal. Mr. Kroloff continued holding and exercising sole control of that, including direct communications with the lender. I have tenants placed there, Your Honor. So it is telling, if you note the timing, no payments have been received since Kroloff took that property, since it was awarded in the court. And as you know, the appellate procedure takes quite a bit. It is an extended journey. Hence, I asked for a stay, which, again, we have so many matters between the civil, the post-divorce, all around the same issue of my homestead. I acknowledge that Amplify is not presently named in that case. Again, I did not have the ability to do so. I was unaware of it. The existing civil action, however, places the alleged fraudulent and concealed origination or the refinancing transaction in issue. I therefore request recognition of the Rule 736.11, a stay and dismissal of its proceeding, or leave for a continuance, Your Honor, so that I may continue and file the appropriate documentation so we can get to the merits of this action, because I do not, as I put, I thought pretty clearly in my response and answer. Amplify, again, is not presently named in that case, and the appellate petition does not yet request cancellation of Amplify's lien. If the court determines that these circumstances, however, prevent mandatory dismissal today, I alternatively request a short continuance, or this application be taken under advisement. Excuse me. Or that the application be denied without prejudice, rather than granting summary foreclosure while the transaction's authorization and its origination remained disputed. These, again, were in place, Your Honor, prior to Amplify 736. I was able to speak with Catherine Cannon, which is interesting because she is also quoted and gave an affidavit. I was able to speak with her earlier or last year, at the end of last year. So they were put on notice of this fraudulent action and have been investigating it. I think it would not be to the benefit of justice, or certainly equity, to allow this expedited foreclosure of this property without addressing those underlying issues, which are substantive, and given time for the correction through the appellate procedure. If not that, then at least allow time for leave to continuance and file the appropriate motions necessary for propagation of this matter. It goes to the heart of what opposing counsel mentioned, which is consent. And I did not and am not a party to that lien at all.
Okay, Mr. Jackson, I just have a few questions for you. So, the property that is at issue in this case, that is subject of the home equity loan, it was awarded to you in the divorce.
Yes, Your Honor.
And along with that, the debt that went with the property.
Actually, Your Honor, there is the issue. Property was awarded to me with the contingency that I would be able to remove Mr. Kroloff within 18 months. There is a condition precedent, however, because my name is not on the note, I could not directly interface with the bank. He was controlling the access, and I think in a contentious divorce, one could imagine what issues that can have when people are not being forthcoming or direct or allowing the opportunity. So throughout the post-divorce dragging.
Well, let me stop you. Because judges do not award residences without the mortgage goes with the property. And so have you been paying this mortgage?
So, Your Honor, that is the problem.
The yes or no question, Mr. Jackson.
Yes, Your Honor. And if you note, the council gave a date of November and December, and that was the issue date that Kroloff took control of the property, cut off and closed accounts that were automatically drawing to the property, and I had no access. That court date, if you wish to have that order, I can send it for review, November 20th. And the order itself is called Order on Amplify relative to that. The court itself notices that I did not have access and that they had to order Mr. Kroloff to give me what's called a 2FA, two-factor authentication. It was a self-serving tactic, Your Honor, because it meant that the property would go back to him in reversion if there were 2 consecutive missed payments. This is a, I don't know where to begin. Again, I'm trying to keep it focused on this. So no, Your Honor, I did not have control of the account. I did not have legal access to the account. Payments were being made until Mr. Kroloff is alleged to have stopped them. He's not here to defend himself, and I want to be precise. The record shows that, Your Honor. Hence my request to counsel and my answer relating to that. Payments were being made on the account. I've had control of the account. The divorce was final May 2025, but I did not have control. Excuse me. I had property without control, and hence the ongoing litigation.
Let me ask you, earlier you mentioned you have tenants in this property?
So it was my homestead, but the divorce proceeding was drawing on, Your Honor. So I had to place tenants temporarily in the property. These were short-term tenants. The tenants I placed in the property were making payments, which were being forwarded to the bank. Again, hence, counsel is speaking of November, December payments. And again, this is when there are actions taken, controlling the account, stopping payments. And again, this is self-serving. I did not have the ability to speak directly with Amplify because Mr. Kroloff did not give the court-ordered access that came with the award in that property. It was kind of like a catch-22. Oh, here you are, here's the property, but you can't interface, and I control the account. And that's before the court right now doing the appeals process. There are 5 appeals, Your Honor, all related to the exact same thing. There's a mandamus. It is it has been a mess. Hence, keeping it again here, there is a prior 736.11 civil action, putting this before the court as early as April of 2025. This matter, it has been noted to Amplify as well. And again, even opposing party mentioned payment dates of starting with November, December, which align with Crawley taking control. The tenants I placed, Your Honor, did not leave until May. I just became aware of this, and there was a service issue because, again, it's in Crawley's name. I could not go and take the mail from that property, Your Honor, while the appellate procedure is ongoing. I found out by chance because I got a notice from the post office and I gave an immediate answer in response, which updated my address. And I have been forthcoming and direct with trying to address this issue, which again, I found out after the fact. Mr. Crawley did not give me notice. Mr. Crawley did not share this information. And Mr. Crawley's interest wasn't not in, I mean, it speaks for itself. He was accepting payments from the temporarily placed tenants, which did not waive my homestead interest in the home. It was just due to the finance around the divorce. I was to move back in May.
Okay. All right. Thank you, Mr. Jackson. And Ms. Schwab, the movement has the final say. So if you have any brief remarks, you may proceed.
I mean, like I said, we've got the deed of trust attached to the original application. It's a standard form deed of trust. It's a lien. He signed it. I don't, he may not be totally understanding what he signed, but that's what he signed. It was a deed of trust, a lien on the property. Again, whatever claims between him and Mr. Kralev regarding, you know, their marital assets is not particularly relevant to this debt. He seems to acknowledge that the debt hasn't been paid. Amplify has physical locations in Austin. If you want to go drop a check off, they would have taken it. So.
Again, Your Honor, if I may, I dispute signing, authorizing, refinance instruments. As counsel mentioned, I'm not under those instruments at all. A deed of trust that was not affiliated with this, and this was the issue that Amplify mentioned. They said it was quite unusual that there was a deed of trust that was signed but did not have any mention or name of Amplify at all. It was a separate instrument. My name is not attached at all to any Amplify refinance. Not just that. The deed of trust was separate. Usually in a deed of trust, it is standard. However, it has the institute's name attached to it. Hence, Your Honor, again, this is not the correct venue for dealing with fraud on these issues. Crawley controlled the contracts and lender account. I had no access whatsoever. Notices were directed to Crawley, not to me. I was deprived of direct lender, recognized access, and notices. The title and refinance controversy predated the foreclosure action today. The December 3rd writ was unexecuted and did not adjudicate the validity of Amplify's lien. And Amplify bears the burden to establish the entitlement to the expedited order. Even if the court grants their application, the order is without prejudice because it has no, it's just, Your Honor, this is, I think counsel can notify the court that I am not attached to any lien instrument. The deed of trust does not have Amplify's name on it. Hence the fraudulent inducement. We were discussing a 25-year term and they were correcting a deed, Your Honor, that for some reason had Petzer's name, not my name. And hence, again, this is not the venue to address that. However, these are substantive issues that, as counsel mentioned, go to consent and authorization and attachment to this lien.
Amplify's name is on the first page of the deed of trust. That's right. His name too.
All right, I've heard everything that I need for purposes of deciding the application and just want to be sure that the record reflects the only case in front of me is this matter in this cause, which is GN 26-003321. The other civil matter and the other family matter are not in front of the court at this date and time, and they are not consolidated. They are not a part of what the court is deciding today. After having reviewed the court's file and having heard from counsel and Mr. Jackson this morning, the court will grant the application. And seeing nothing else, you are excused from the virtual courtroom.
Thank you.
Okay, thank you. Okay, that will take us to our next hearing this morning, which is Michael Bodnar Ventures versus Quality Container. Let me give everybody a moment to get back to their computer screen. Okay. We make sure the court reporter is ready. I see she is. We are here on cause number GN 25-008741, Michael Bodnar Ventures LLC versus Quality Container Builders LLC on the plaintiff's motion for a default judgment. Mr. Bowman, you may proceed.
Thank you, Your Honor. Your Honor, we filed the original petition on September 10th, 2025. Service of process was performed, and the affidavit dated October 6, 2025 of the registered agent of Bob's Containers for service on that registered agent was completed, and then it has been filed since October 7 of 2025. No answer has been made by the defendant. We filed our motion for default judgment March 2nd. Thereafter, just trying to get hearing dates, we ended up here today. So now we are here presenting the motion for default judgment itself. The motion contains the invoice that was the function of Mr. Bodnar paying half of the invoice amount for the building of the unit. And then it also contains my affidavit for fees and costs incurred up to that time. I have, for presentation today, 2 subsequent small, but need to go ahead and do the bills that were done in June and April, and would present my supplement through oral testimony to my affidavit, but my affidavit certainly is the majority of the attorney's fees. In order to prove up the invoice and the expenditures, I would call Michael Bodnar.
Okay. All right, Mr. Bodnar, if you'd raise your right hand and be sworn. Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, go ahead, counsel.
Hi, Michael. Are you the principal for Michael Bodnar Ventures LLC?
Yes, I am.
And did you engage in a contract with the defendant on behalf of the company?
Yes, I did.
And as part of that, was the purchase price set forth in a invoice that was sent to you?
Yes, it was.
Samantha, can you please show Exhibit A to Mr. Bodnar? Your Honor, may Ms. Baines have permission to publish?
She has permission. You may share your screen.
Thank you. Is this the invoice, Mr. Bodnar, that you were received?
Yes, it is.
And on behalf of Bodnar Ventures LLC, did you submit payment to Bob's Containers of that amount?
Yes, I did.
Okay, and that
I believe it was 50% of that.
Correct. And that amount was $83,942.50.
Correct.
And did you receive anything in return for that payment?
No.
And have you received anything to date on from Bob's Containers?
No.
All right. And are you here today suing Bob's Containers for the return of that $83,000?
Yes, I am.
And did you also incur attorney's fees on behalf of the company in trying to file this suit and obtain the damages that you have suffered?
Yes, I did.
And are you asking the court to pay you those attorney's fees incurred? or to award you those attorney's fees incurred.
Yes, please.
Okay. No further questions for Mr. Bodnar.
Okay. All right. And the exhibit that was shown is attached to your motion, so I don't think you need to offer that. But Mr. Bowman, did you indicate you have some additional attorney's fees invoices and you wanted to offer those into evidence?
Yes, Your Honor, I did, and I was going to call myself next about that to prove it up. I have exhibits 12 and 13. These are two redacted fee statements that were sent out after the submission of my affidavit attached to the motion for default judgment.
Okay. And have you uploaded P12 and P13 to the box?
Yes.
Okay, great. I'll swear you in, Mr. Bowman.
Thank you.
Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
Thank you, Your Honor. I offer what was attached as exhibit C to our motion, which is my affidavit. What was stated therein at the time was true and correct, and ask the court to admit that.
Okay, so the court reporter uses, so it's got to be P and a number.
Oh, okay. My affidavit. Samantha, do we have it as a separate?
Yes, it's P5, Your Honor.
Oh, great. P5 is admitted.
Offer P5, thank you. And then in addition to P5, Your Honor, there were two subsequent invoices that were issued for time and expend on trying to get this set for hearing and getting the matter wrapped up. Those are exhibits P12 and P13. I offer those at this time.
Those are admitted.
And then in addition to those, Your Honor, in preparing for this hearing, going back through, making sure I had all the exhibits, making sure Ms. Baines was aware of it, the attorney who was originally the preparer of this motion is out of the office on another hearing. And so in order to prepare for this hearing, Ms. Baines and I also equally spent estimation of 2 hours both preparing for and attending this hearing here today for a total of $2,150. My hourly rate is $550 an hour on this file, and Ms. Baines is $350. So that all being said, Your Honor, I believe that the total fees and costs or fees and expenses incurred by Bodnar Ventures since my firm was retained in September of 2025 is $9,612.50. And we have also, I think, $371.35 in costs. And I believe that the calculation of prejudgment interests to date would be $5,262.22.
Okay. All right, and you have a proposed default judgment that sets out all of the requested relief?
We do, Your Honor. We filed, I believe, a revised version yesterday. It is order granting plaintiff's motion for default judgment in a total of the amount of $99,188.57 plus post-judgment interest set forth at 6.75, and then appellate fee estimates in the event that this gets appealed somehow.
Okay. Understood. Okay, let me just go over a couple of things with you, Mr. Bowman. So for, I guess, first things first, you actually have a vacation letter on file for this date and time, which is a little bit, I don't know, somewhere between humorous and puzzling. I guess that conflict went away since you indeed set a hearing on this date and time.
To clarify that, Your Honor, I practice with my wife, and my wife has been playing 3-card Monte with our summer vacation. And so, yes, when it was filed, this was blocked off, but it has not been the date that we ended up going out of town.
Okay. Fair enough. Okay, the other thing that I am going to ask you to do, Mr. Bowman, is in reviewing the motion itself, I do not see a certificate of service on the motion. Now I know and I understand the defendant has defaulted and has not answered. However, I believe pleadings still have to be served under the rules of civil procedure. So what I'm going to do is this. I'm going to ask simply that your office drop the motion in the mail today. And you can file the certificate of service with the clerk and send that to Ms. Seeger. She's my assistant who provided the Zoom link to you. Actually, you do have a certificate of service.
I was going to wait until you were finished, but yes.
Okay, you do have one, but I guess it was e-filed, and so.
Well, the certificate is that
Okay.
each party or attorney was served in accordance with Texas rules of civil procedure.
Okay, and so my question for you is, did your office indeed mail it to the defendant at their last known address?
That is my understanding, Your Honor. I can verify that with the personnel who would have done it, but it is my understanding, and I know that we certainly mailed, for example, the notice of this hearing as well via certified. So we have been communicating via certified mail.
Okay. And see, there is no notice of hearing in the court's file. So that actually was another thing I was going to mention. Our local rule does require hearing notices. And I don't know if you've noticed it unless the hearing notice gets filed. So that may be just a reminder for your staff. What I'm going to do is I'm going to hold on to this. I'm going to let you, Mr. Bowman, confirm with your staff that this certificate of service is indeed accurate and that it was mailed to defendants. If you could just let Ms. Seeger know indeed that was accomplished, then I'm satisfied that the default can be granted.
Okay, and in the alternative, you said you wanted me to put it in the mail and submit the certificate of certified mail.
Yeah, just a certificate of service that indicates to the court it went to defendant at their last known address.
Sure.
I will take the motion under advisement if that needs to be accomplished. And then I think it's safe to presume that if no response to the motion or answer is on file by the end of this month, that the court would go ahead and grant the motion for default judgment.
Very good, and we'll make sure to file the notice of proceeding today because I know that we did that, so I don't know why it wasn't filed.
Oh, okay. The notice of hearing you did
Yes.
send it just didn't get filed.
Correct.
Okay. Well,
If you don't see it, then it didn't get filed.
your vacation letter is the only notice that we have. So yes.
All right.
All right.
We'll make sure to take care of that.
It sounds like that this will be taken care of either today or by the end of next week then.
Very
Any
good.
questions for me?
I don't believe so.
Okay. Well, thanks for your patience with the busy docket. Y'all are excused from the virtual courtroom.
Thank you, Your Honor.
Thank you, Your Honor.
Take care.
Your Honor.
As well.
Best of luck. Okay. That is going to take us to Douglas versus Zamora.
Yes, good morning, Your Honor.
Good morning.
Good morning.
All right, I'm going to go ahead and call the case. We are on record on cause number GN24. Excuse me, just 1 second. Okay, sorry about that. Okay, we'll go on record in cause number GN24-008789, Douglas versus Zamora. Let's start with appearances for the record.
This is Tania Godinez for the defendant.
This is Andre Douglas, pro se plaintiff.
Okay. And it's defendant's motion to dismiss for want of prosecution. So Ms. Godinez, you may proceed.
Thank you, Your Honor. This case arises from a motor vehicle accident which occurred on November 12, 2023. Plaintiff filed his petition on October 28, 2024, and defendant answered on January 10th, 2025. Like you mentioned, we're here today on defendant's motion to dismiss for want of prosecution in accordance with Texas Rule of Civil Procedure 165A. Seeking a dismissal of this case under pro se plaintiff's failure to prosecute his case with due diligence. The length of time that has gone by since the pro se plaintiff filed his petition, like I said, October 28, 2024, his failure to provide defendant with proper and complete discovery responses in direct opposition to 2 judge orders from hearings we have now attended on motions to compel. Those are shown in defendant's exhibits 3 and 6. Pro se plaintiff's failure to appear at the pretrial hearing. He unilaterally set himself his refusal to mediate the case or engage in informal negotiations. And to this day, he still hasn't provided outstanding discovery requests, despite numerous attempts to work with him, as shown in defendant exhibits 1, 2, 4, and 5. As such, and because we appear to have exhausted all available avenues to the defense and attempts to work with him, we have appeared at numerous hearings, like I mentioned, contacted him numerous times via phone, letter, emails. We respectfully request this honorable court grant defendant's motion to dismiss for want of prosecution under Texas Rule of Civil Procedure 165 as to his lack of due diligence, but also under the court's inherent powers. Thank you, Your Honor.
Okay, thank you. All right, Mr. Douglas, before you proceed, I'm going to swear you in. If you would raise your right hand. Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, go ahead.
Good morning. So this, I'm operating pro se. I'm not a lawyer, so, bear with me. My main defense is against Ms. Godinez is one of the main reasons why there's been a delay on my part for submitting the court order documents. Is there's been 2 family emergency or like crises that I've gone through since earlier this year. One was actually was regarding my nephew, and that was a result of that. I missed a hearing, and then recently I just had my grandmother passed in mid-May, and around this time I was working on those court order responses, and maybe, I believe, if I'm not mistaken, on or around May 27th, Ms. Godinez, she gave me like an extended deadline to submit the responses, which was like May 29th. And because of that, the family emergency, I was out of town, and my grandmother, she lives like all the way in Florida, so that really just slowed me down in getting all my documents ready. But since then, I've been actively trying to get all the documents together and file everything. And at the same time, we also been pursuing mediation from May up to maybe mid-June. There's been multiple correspondence between me, her, and her assistant concerning scheduling mediation. There's been some conflict regarding that. Mainly, my issue is not able to get a mediator that is, you know, that we can agree on, and that is, you know, but like you saying, you know, I'm sorry. Also, as I was trying to finish up the responses that was court ordered, and the mediation was also, we were also at the same time trying to schedule that, and she's giving me recommendations. I'm calling the mediators, trying to, you know, ask questions, see whether or not I'm in agreement with them. So I'm also asking her questions via email, just for like record purposes, on pretty much just trying to figure out why she chose the mediator and if I feel comfortable with them or not. And I've also given her mediation that I found through the Travis County District Court website. Doesn't seem like she wants to consider that, because she does not, she's not able to, they don't, it's like a random selection for the mediators. So I think that was a conflict with her and her firm, but I believe it would be in best, it would be good for both of us, because the mediator, we won't know them. So it won't be biased, and the mediation she's asking for, they've been dealing with them for years. So I don't feel comfortable with the mediation she's trying to recommend. But hope I'm not too much all over the place. And to add on with the delay in me filing things, her assistant, I believe it was early June or end of May, said something along the lines of, correct me if I'm wrong, Ms. Godinez, if I don't file the required responses, discovery responses, then I might have to compel mediation to like September or August. So at that point, you know, there was no talks about dismissing anything. So I'm trying to hurry up, submit documents and everything, and then a week later, there was more communication, like early June, concerning getting mediation, and we weren't able to come to an agreement. So maybe a week after that, like around June 12th, there was a vacation letter from Ms. Godinez that was submitted, filed into court, and I got a copy as well, saying that she requested that nothing be scheduled or set during her vacation period. The main one that's important, that's close, is recent was June 29th of 2026 to July 13th. So at that, you know, so that kind of blocked out a time frame where I actually planned on getting some mediation scheduled, because I was actually going to send her some of my availability for those couple weeks. So that kind of messed things up for me. And then maybe not long after that, she filed, or one of her representatives filed the motion to dismiss during the time that she was supposedly, you know, on vacation. But in her vacation letter, she was saying she doesn't want anything to be set. So that just kind of is in conflict with her request. I actually honored her request to not schedule anything during that period, but, you know, she went ahead and scheduled a dismissal. So now I'm frantically, well, not frantically, but I had to shift my focus to respond to that motion to dismiss. That just came out of nowhere and out of all times is during that time period where she's supposed to be on vacation. So, you know, she submitted that request in like June 30th, which is like a day after her vacation started. And also, it was actually on file in the case summary history and like accepted and everything on July 10th. So, which is also within that that vacation time frame. So it's just really inconvenient. And prior to that, I mentioned they said something about compelling mediation again in August or September. So it's like during that time, it was just a little confusing. It's like, you know, do you want to dismiss or do you want to file mediation? Like I'm sorry. I'm just trying to communicate that despite what Ms. Godinez is saying, I have actively been trying to do my part in helping this case to move forward and catch up. It's just that family emergency, and then the burden of her most recent filings unexpectedly. It kind of shifted my focus from getting everything I'm trying to file to catch up. And just that vacation letter was like a really big inconvenience, you know, especially when we're actively trying to do mediation. And so I'm not sure if that was on purpose, but it was just, I'm just bringing that up to say that I just hope to at least get a continuance on the matter to give me more, like a week or two to file those documents that I was compelled to file. Or, you know, best case scenario is retain the case on the docket, because I'm almost done with those discovery responses, you know. And I've attached to the I submitted an email that has a list of our email correspondences that does show I have not just been sitting on my tail. I have been actively trying to get things moving forward. I've also submitted a correspondence between me and the Dispute Resolution Center, me trying to get availability for after Ms. Godinez's vacation period is up. I didn't schedule anything. I let them know, like, hey, what's your availability after July 13th? And they gave me the times. I said, hey, I can't set anything yet. I need to wait for, you know, Ms. Godinez to come back from her vacation. So it was just a little unfair that I'm trying to honor, you know, these, you know, the things that she's filing is, you know, but she's not actually keeping her own request. So I'm just asking for a little bit more time to file those discovery responses, and then it would be a big help if that burden of that dismissal could be removed. That really just shifted my focus. I'm sorry if I was long-winded. That's all I got.
Okay, thank you. All right, the movement has the final word, Ms. Godinez.
Okay, thank you. If I may address the vacation letter, first of all.
Sure.
That is for our lead attorney, Mr. Edward Osuna, not for myself. So I haven't been on vacation. It was for him. So I understand he might be confused as to what that vacation letter means. But we've been actively working on this case. As far as the original discovery deadline, that was March 12, 2025. So we've been attempting to get these responses in order to properly evaluate the case and continue effective litigation since then. It has been well over a year. And as for the mediation deadline, when we talked about compelling, mediation deadline, according to our docket control order, is coming up August 14th, 2026. All of those attempts he's discussing have come from our office. We actually already had a date on hold. The mediator we had selected is actually a plaintiff's attorney. And we advised them to please look into the mediators. We proposed quite a few. We gave them contact information. We said, please contact the mediators, ask them the questions that you have, because we've tried to assist as much as we could within the confines of our own client's representation. We provided him with Texas rules of civil procedure that were applicable. So he, as to him, for him to have a guide. He's a pro se plaintiff, but we can only do so much. So, like I said, all of those attempts have come from our office. The last date that we had on hold with the mediator, Mr. Douglas advised us the day before that he would not be proceeding with mediation. We tried to select a mediator that is well known in Travis County. It was Mr. Mike Rubin. We also were considerate of the cost to him. So he's a little bit more affordable. So we've been very considerate with Mr. Douglas. Now we're running out of relief. This has become very expensive litigation for the defense side, just trying to get all of these things from Mr. Douglas. And now this motion is a last resort. He's been advised ever since we filed our answer on this matter. Thank you, Your Honor.
All right, thank you. Okay, so a couple of things here I want everybody to understand is that the rules of judicial administration set out timetables for which contested civil jury cases should be disposed of. That time frame is 18 months from, generally speaking, the date the defendant appears or enters an answer in the case. This case is run up we're right at the 19th month. So, Mr. Douglas, you did not proceed according to those rules. However, I understand you're proceeding pro se, and I understand you have had some things that you've dealt with as far as family issues. I'm not going to grant the dismissal for want of prosecution at this point in time. So I'll deny the motion without prejudice today. But I'm going to do two other things. I am going to order the parties to mediate this case within the next 60 days. I am going to appoint a mediator off of the mediator wheel. So I understand, Mr. Douglas, why Ms. Godinez wants to recommend mediators that they've used, because they know who has been successful at helping them get cases resolved. However, on the flip side is you are suspicious of that, and that is exactly why we have a wheel. So these are attorneys who have applied to be mediators, to be appointed by the courts to serve, and we will simply appoint the next lawyer on the wheel to handle the mediation in this case. So I need to check and see who's up next, and we'll get that name and put it in an order. The second thing I'm going to do is I'm going to order and require that this case be set for trial before the end of 2026. So, Mr. Douglas, you and Ms. Godinez need to have a conversation soon about when this case can be set for trial for October, November, December. It's been on the docket for long enough, and it needs to get set. Okay? Any questions about the court's rulings?
It is set for trial, Your Honor, for September 28th, 2026. And that's one of the things we did. We entered a docket control order to give this case structure. He hasn't abided by any of those deadlines either.
Okay. Well, so you're from out of town, I take it?
Yes, ma'am.
Okay. No, nothing wrong with that. I love San Antonio. Fun place to go. Often people miss that, even lawyers in town, out of town. when you enter a scheduling order, you must contact court administration to actually get it set for a trial. This case, I do not see that it has actually been set for trial. You may have a scheduling order, but no one contacted court administration to get it set on the jury docket. It is not set on the jury docket, period, September or otherwise.
Okay, Your Honor. Thank you. I appreciate it.
Well, yeah, so I think, and at this point, we're nearly to August, so if you called and set it on the jury docket, it would not be reached in all likelihood because you would be so low down on the list. So looking later this year, I think hopefully you can identify a date and get that set. If these things are not accomplished, Mr. Douglas, if the mediation does not occur within the next 60 days, and if the trial is not set by the end of 2026, then I will order that the case be dismissed for want of prosecution. Okay, so these are requirements. Any questions?
No, Your
Yes, sir.
Honor.
Okay,
Yes, Your
Mr. What's the question?
How will we be notified on what mediator has been selected, or do we need to start that process on our own?
No, I've indicated that I'm going to appoint the next mediator on the wheel.
Okay.
The courts are required to keep a wheel. This is a random assignment of lawyers who've said, I'm available and I would like to be able to serve as a mediator. So my briefing attorney is pulling up that list to see who is next. We're going to plug that name into the order, which I referred to, but basically it will be an order denying the motion to dismiss for want of prosecution without prejudice to refiling, requiring the parties to mediate this case within the next 60 days, requiring the parties to set this case for trial before the end of 2026. And if these things are not done, then the case will be automatically, without further order of the court, dismissed for want of prosecution. Okay, so the other thing I will tell you, Mr. Douglas, it's not in front of the court today, but Ms. Godinez mentioned you've been ordered to provide discovery responses. She's telling me that either you haven't done that or you haven't done that to her satisfaction. That's part of their motion, but I don't think it's really the best use of a dismissal for want of prosecution. But if you don't get those discovery answers dismissed, I will say that there is the possibility of further discovery, motion, or sanctions, and parties that do not fully comply with court orders and do not respond to written discovery are in jeopardy of being unable to present their claims or defenses for failure to follow the rules. So you need to endeavor to comply with the court orders and whatever agreements y'all have about discovery, or you may further jeopardize your lawsuit. Do you understand that?
Yes, Your Honor.
Okay, so I understand things have happened, but at the end of the day, if they don't have your full and complete discovery responses and the case is going to trial, there could be some very adverse consequences. So you need to take care of that.
Yes, Your Honor.
Okay. That concludes our work on this case. So I will excuse you all from the virtual courtroom. Ms. Godinez, my briefing attorney is going to get the name of the attorney next up on the wheel. But so if you will present an order with the court's rulings and just leave a blank for the court to fill in that name, and that can be emailed to Ms. Seeger.
Absolutely, Your Honor. Thank you.
Okay. All right. Thank you. Y'all are free to go.
Appreciate it. Thank you, Your Honor. Have a nice
Thank you, Your Honor.
Take care. Best of luck to you.
Thank you.
All right, let me check with Miss Simon. Janice, do you need a break or are you okay? You good? Okay. All right, we're gonna go down to our next case, which is our everyone's favorite, a motion to compel.
In your honor, I'm not going to have a speaking role in this hearing. Are you okay with me keeping my camera off, or would you prefer I keep it on?
Camera off is fine, Miss Crow. And remind me, which one is your client?
Yes, your honor. I represent Austin American Awning and the three gentlemen, Mr. Cortez, Mr. Rendon, and Mr. Lopez.
Okay. Yes, you're free to turn your video off.
Thank you, your honor.
Okay. We are here on cause number GN25-003994, Staver versus CBRE et al. Let's start with appearances, please.
Erin Hamilton, plaintiffs, and I have Haley Frazier. Her video's off, but she's a law clerk with us right now.
Rhonda Payne for CBRE Inc.
And Deb Greenlee for CSHV, or simply the Hill Country Galleria.
Jacqueline Golden for Prebe Security, and I'm also not speaking today, so may I turn my camera off, Your Honor?
Yes, you may.
Thank you.
Your Honor, Fallon Schwartz, I'm with Deb Greenleaf with CSHV. I'm not speaking, I'm just taking notes. May I turn off my camera?
Yes.
Thank you, Your Honor.
Thank you. Okay. All right, and we're here on the motion to compel, so the movement may proceed.
Sure. Hi, Your Honor. Thank you for the time. First off, just as a high-level overview, we represent plaintiffs. Obviously, little girl, 3-year-old. Her name is Addison. She was with her mom and her baby brother. If you're familiar with the Hill Country Galleria, it's an outdoor mall. At kind of a fitness for mom or fit for moms, but it was like a mommy and me workout type class situation. About a year ago, a little over a year ago. They were crossing on kind of a run as part of the Fit for Mom class, crossing a crosswalk. It's very obvious. It's designated by different pavers, it goes asphalt to pavers. And there was a car parked illegally, providing services to a tenant there called Tony C's. They were putting awning services up. And so the little girl crossed on her scooter with her mom right behind her, and was hit by a car coming in that did not see her. And so that's essentially kind of why we're here. Life-changing injuries to the little girl. She was in 100 days. She was in a coma, has lost hearing in an ear. And luckily she's still alive and recovering, but that's kind of where we are today and why we're here. So currently where we are is we have started depositions. We're in the discovery process. Defendant CSHV is the owner of the property of Hill Country Galleria, and then defendant CBRE is the property manager. And so we have gone back and forth through the discovery process. Each defendant has been responsive, but they have not been fully responsive. They've raised a bunch of objections that we disagree with. And they've also, we sent out deficiency letters, and, obviously that's why we have filed our motion to compel, is that we haven't gotten the information that we need. So this is a premise liability case. So we need to be able to establish that we have actual or constructive knowledge of, or that we need to be able to establish defendants had actual constructive knowledge of a dangerous condition that they knew of or that they should have known. And so that's the information that we are trying to seek from each defendant that we have been unable to receive at this point. So if it's okay with you, I will go through each defendant separately.
That's fine.
Okay. So for CSHV first, I think the big objection is essentially that we want to understand who is in control over the Hill Country Galleria. So CSHV is the owner. But, you know, we need to have a good understanding of, you know, what individuals do we need to ask? Who do we need to depose? How things are operated? You know, who delegated stuff? How was stuff monitored? They had a contract with CBRE, the other defendant, at trial or at this hearing today, to manage the property, but you know, who is doing that? And so, you know, how we need all this information to ensure that CSHV was doing their job to make sure that their property was, you know, the property that they owned was functioning at least at minimum safety standards. How they, you know, how they set up their business, their structure, etc. So, as you'll see, like specifically, we have, you know, we have 2 interrogatories that are at stake with CSHV. You know, the first one is, you know, it kind of goes to just what I was saying in general, like, we need to know who is responsible, who is delegating, and you know, how that worked, who we need to talk with, and, you know, what other questions that we need to ask to make sure that they were doing their job as a property owner, to make sure that, you know, was CBRE the right person in place, and was it being done responsibly, and were they monitoring it, were they managing it, or were they not? And so we also have some RFPs with them as well. But you know, it's very interrelated. I asked, you know, for them to be separated, but same thing, you know, who hired CBRE, who was monitoring that relationship and making sure that it was moving forward as it should be. And so, you know, some of the things that we're asking for are just very basic information about and documents on kind of the ownership management and the operational control. And then for CBRE, it's also similar. They're the management property here. You know, I think a lot of their objections have been that CBRE, if you're familiar with them, they're a very large company. They have properties all over the world. And so a lot of their objections are based on that it's a fishing expedition, essentially. And, you know, and we need limitations. So we aren't opposed to limitations necessarily, but that hasn't even been brought to the table. We don't necessarily think that limitations on location are that important. For us, it's the knowledge that they had, what they knew, and has, you know, from past experiences that's been brought to their attention that would allow them to, you know, to make corrections at further properties that they manage, that were or were not made at the Hill Country Galleria that they were managing. And so that's kind of our big claim is we aren't opposed to limitations. We don't think locality, you know, time, I think, is something we can discuss, but the problem is that there has been zero conference or conferral on this. We've sent the deficiency letters. The parties have supplemented and have been responsive, but have raised a lot of objections and have not, essentially are not providing the information we need to establish our case.
Okay. Right, who wants to go first?
Your Honor, I'll go first for HSCV, and if you don't mind, I'll refer to that defendant as Hill Country Galleria for the sake of simplicity.
That's fine.
And so, Your Honor, with regard to, first of all, I'd like you to keep in mind that my client purchased this open shopping mall in 2014, and it covers about 1.3 million square feet. So when in interrogatory number 1, plaintiff's asking for the identity of all the officers, directors, managers, managing members of CSHV is essential to establishing the identity of an individual who exercised control over the property. First of all, control is really not an issue. We have admitted that we own the property. And what it is if they could simply modify their request to find out which particular member or director, or there may be one or two of them from CSHV actually interfaced with the management company, instead of like going back 12 years, and for the numerous members of the ownership, there would be a much better interrogatory, and it would, we would be able to then identify the one or two specific people that interfaces with the property management company, and that we just ask that the court ask them to modify their interrogatory number 1. Now, interrogatory number 4, unless you want me to stop there, if you want to rule as I go, or.
No, I'm not going to do that. You can
Okay.
go, you can proceed.
Okay, so in interrogatory number 4, this particular interrogatory was not addressed in the discovery deficiency letter. And we did have a conference over that. Therefore, plaintiffs failed to confer, and Hill Country Galleria asked the court to deny that interrogatory. More specifically, in interrogatory number 4, Hill Country Galleria has identified CBRE as a property management company who has the responsibility for the installation, placement, maintenance of signage and traffic control device on the property, and any further information regarding that subject or those subjects should be referred to CBRE and not to Hill Country Galleria. So we ask this court to deny the motion to compel, as number 4 is moot, as we don't handle the day-to-day operations. With request for number 34, plaintiffs requested documents defining CBRE's scope of work, duties, responsibilities, maintenance obligations, and inspection protocols at the property. This request for production includes non-relevant matters beyond what is relevant in this case. We did object that the request was overly broad and not limited in time. As I stated before, we've had a relationship with this security company for over 10 years, and we've owned it for 12 years. And a much more narrow request would be better. What plaintiffs have made an issue of specifically is enforcement of the parking rules, communications with contractors of tenants, and the signage and the traffic controls. And we produce the property management company, which incorporates the scope of work for CBRE, and it's not quite clear to us what else plaintiffs want, other than every single document with CBRE from the time of the relationship began in February of 2015. And that's my exhibit B-2. And we think the request for documents for over an 11-year period is overly broad. Jumping to request for production number 35, plaintiffs request all correspondence, incident reports, notice of defects, hazardous conditions involving CBRE. Besides being overly broad and a fishing expedition, this request covers non-relevant matters and does not define what defects and hazardous conditions they're looking for. I've cited in my response the HEB case that talked about incident reports. And in that case, the 14th Court of Appeals, they limited the incident reports to what happened was a slip and fall, trip and fall situation. And plaintiff's request in this case does not limit the incident reports. In our case, plaintiff is asking for the whole universe of incident reports, which could be tripping, robberies, a customer needing medical attention, a lost child, a car was broken into over a span of more than a decade. We ask the court to limit plaintiff's request for incident reports to incidents that are related to auto pedestrian incidents or a vehicle blocking another vehicle's view. That makes much more sense and conforms with the court ruling in HEB. And finally, request for number 37, plaintiffs ask for all invoices, payment records, and financial documentation for services rendered by CBRE. Again, this spans a 10 or 11-year period. The request is overly broad, not limited in time. And first of all, we don't see how financial records, what CBRE gets paid for their services, is even relevant. And second, the Texas Rule of Civil Procedure 192(3)(a) permits discovery of any matter that is not privileged and is relevant to the subject matter of pending action. Evidence is relevant if it has a tendency to make a fact of consequence more or less. And this is basically a premise liability case. Financial records are not relevant to whether a dangerous condition existed on the property. And plaintiffs loosely claim that documentation of payments from Hill Country Hyatt to CBRE go to the ownership, management, operation, control. However, there's no denying that CSHV owns Hill Country Hyatt, and we own the shopping mall where the incident occurred, and that we hired CBRE as our property management company. We've admitted all this. And we just asked the court to deny plaintiffs' motions to compel discovery responses from CSHV, or at least tailor the request so that they are relevant and narrowly tailored. And that's all I have.
Okay, Ms. Payne.
Good morning, Your Honor. So most of the requests that we're here today about are asking for irrelevant information, which makes them overbroad, and they're not reasonably tailored at all. And they have the burden of complying with the discovery rules. We shouldn't have to redraft their requests for them. Interrogatory number 1 asks for the names and addresses of all officers, directors, managers, and managing members of CBRE. They claim they need this information because it's relevant to the management authority. CBRE has already admitted in their discovery responses that it manages the Hill Country Galleria. They have already been provided a copy of the management contract and the assignment to CBRE. As mentioned, CBRE is a very large company. They're global. They have clients in over 100 countries. So when they're asking for names of managers in over 100 countries with no time limit, which is essentially over 30 years, it's kind of absurd and would take a lot of manpower to get this information. And all these people, most if not all of these people that they're asking for information on, will have zero knowledge of the Hill Country Galleria or what happened in this incident. That knowledge resolves with the CBRE employees that are on site every day managing this property. There is a manager of the Hill Country Galleria. He responded and verified the interrogatories. They haven't asked to depose him. They haven't asked any questions about which individuals at CBRE would have knowledge. Instead, they just start at the top and want all this information about the top executives of a global company, and it's not relevant. Request production number 20, requests all documents relating to any claim whatsoever for personal injury or property damage arising from the incident at Hill Country Galleria from 5 years before the accident to the present. And they don't limit their request to the type of dangerous condition that they're claiming, which is either a problem with the parking or a problem with signage or traffic control or marking of crosswalks or anything like that. So the way that they have it worded, they're asking for any claim, whether it's by a tenant, a retail tenant about damage to their property because of some condition in the space they lease, or slip and falls inside stores or restaurants, or anything. None of that has to do with a motor vehicle or a pedestrian. So that information, most of it is not relevant, and they have a lot more claims for contract disputes than they do personal injury claims. Request for production number 21 asks for organizational documents. which again are not relevant. This is not going to give them the information they need. They say they need it for management, or sorry, for the management operations relevant to the scope of CBRE's management operations, which it is not. They already have the management contract. But even though they're not relevant, CBRE's bylaws, certificate of incorporation, and governance documents are publicly available for download at their website. Request for production number 22 asks for parent companies, subsidiaries, affiliates, or related entities of CBRE. Their parent companies, subsidiaries, affiliates, none of that's relevant to the management operations at Hill Country Galleria in Bee Cave, Texas. That information is not going to tell them whether there was a dangerous condition, what CBRE knew or didn't know, or anything like that. Request for production number 46 and 47 asks for any and all emails, documents, records, orders, and documentation regarding any and all properties or complexes owned or managed by CBRE anywhere in the world for essentially the last 30 plus years. This information is not relevant. This would require them to produce just so much information that's not relevant, including every commercial tenant lease executed anywhere in the world over the last 30 years. It's just completely overbroad. I also objected to I also made a privileged objection, not because of anything that has been identified, but just that the requests are so broad that they encompass attorney-client privilege, communications, and completely unrelated claims. They complain we haven't produced a privilege log, but there's nothing to put in the privilege log. Again, this was an objection made because of the overbroad nature of their request. Encompass some of those communications. And lastly, Plaintiffs' Counsel mentioned that there was no discussion about the limitations, and that's just not the case. At the end of our motion, I included an email thread back in March where we communicated with the lead attorney and we explained CBRE's global presence and why this was so overbroad, and asked that he limit it by geography, type of facility being managed, etc. And he ended up shutting down communications that day. There were no more communications about discovery for 3 months. And then he sent a deficiency letter basically reiterating the same things we talked about in March. So there have been discussions. He just has chosen not to narrow any of the requests. That's all I have. Thank you.
All right, Ms. Hamilton, the movement has the final say.
Yeah, I mean, Your Honor, I think kind of, you know, where we're at is that so little has been provided that we can't move forward at this point. So we are not opposed to limiting. You know, that is not off the table at all. But you know, in general, like we just, you know, the historical information is important. The you know, knowing what they knew prior to the incident is very important, and what they did or did not do is very important in general. And so, you know, I can go through each of those and each of the arguments if I have enough time and give you a response to it, but it's just almost nothing has been produced. That's not true. Things have been produced, but very little has been produced. And so rather than it being us working together and discussing on limitations, and I know we'll have disagreements on it, but you know, we have to be able to establish that they either knew or should have known that there was a dangerous condition. And to date, we have not received anything that allows us to do that.
I have a request for you. It is most helpful for me if I have an order that looks like this. It is just a standard form order, and it has each request that is the subject of the motion, request, response, including objections, and then it has either a blank or a column where the court can mark, sustained, overruled. And I will go through them one by one based on the arguments I've heard here in the courtroom today. But I will just say it is not my job to rewrite discovery requests. So if I feel that an objection needs to be sustained, it's going to be sustained. And it's, up to the parties to, if you need to send narrowly tailored discovery requests, that's what the rules require. But I will rule on the interrogatories or requests one by one based on the request, the response, and objections. And if you need me to provide a sample of the order I'm talking about, my briefing attorney can send one to you. But if I don't have an order like that, then I'm shuffling between the motion, the response, and it's a lot more labor intensive. Whereas if everything's in one place, I can quickly review them, make a determination of whether I want to sustain or overrule the objections. Make sense?
Yes,
does.
Should we, I mean, I think we submitted the kind of order that you are talking about, but I wouldn't mind reaching out to your briefing attorney to get a copy of the order that you prefer.
Okay. Well, and I just haven't seen it, Miss Greenleaf, so it's possible it's pretty close to what we're talking about. But Mr. Woodby is my briefing attorney, and I can have him reach out with just a form that we've found makes this process a little bit.
Appreciate it, Your Honor.
Okay.
Likewise, CBRE submitted a proposed order, and I think we had everything except the full response. So we will do that and submit a new one.
Okay, great.
And same for plaintiffs. Thank you, Your Honor.
Okay, all right. So I'll take this matter under advisement. I will go through them one by one. I'll provide the rulings that you need. And let's see. It looks like you have, do y'all have a scheduling order in place on this one?
Yes, Your Honor.
Okay. All right. And is it set for trial? It's not.
I believe it's set for trial in August.
Yeah, I believe it is.
27.
Okay. So you might want to just confirm that with court administration. This is the only hearing that shows up for this case, and typically a jury setting would be showing for me. So you might just want to confirm that.
Thank you.
All right. Thank you. Yeah, it's not showing up for me. It may still be there, but it's best for you to double check that now. All right, y'all are excused.
Thank you.
Thank you.
Thanks. Take care.
You too.
All right. I think we might need, let's see. Right. And Ms. Balderrama, I think you said you wanted a record. Is that right?
Yes, that's correct, Your Honor. And may I just mention one thing?
Yes.
We had trouble accessing the link, the box link, and we have our exhibits. They were all part of the motion for default. But I noticed that you guys like those uploaded, so I'll leave it at your discretion if you want me to reset this so I can get this resolved.
Well, if all of the exhibits were attached to the motion, I don't know why you would need to.
Oh, okay, that's what I wasn't sure, because I was reading through the rules, and so when we got your email yesterday, my assistant was asking, should we go ahead and upload them also? So my apologies, I wasn't sure.
Well, they're in the court's file, so.
Oh, okay. Just making sure then.
Okay. All right. We are here this morning on cause number GN25-004980, Ryder Integrated Logistics Inc. versus Diaz. You may proceed.
Thank you, Your Honor. My name is Aguila Valderrama, and I am the attorney representing the plaintiff, Ryder Integrated Logistics Inc. Your Honor, we're here on plaintiff's motion for default judgment against Alfredo Villaramos, who was working under a DBA, but we are considering him as an individual in this matter and not a company. The record reflects that a defendant was properly served with citation on 7/29/2025. The citation is on file with the court. And more than the time prescribed by the Texas Rules of Civil Procedure have passed, and defendant has failed to answer, appear, or respond to the matter we have in front of us here. So the defendant is in default. We did submit with our motion for default judgment an affidavit as to the non-military service of this defendant. Like I said, he was acting as I apologize, as a DBA, but is still considered an individual under the rules. So we did provide an affidavit of military status for the court. We have also submitted an affidavit from Paul Garcia. He is the partner and attorney of record for our plaintiff. And we have also submitted all of the business records pertaining to this matter. And the damages established are $259,556.40. We have also submitted an affidavit for Mr. Garcia's attorney's fees, which are a total of, I apologize, $5,180. You know, there are court costs and, you know, any interest that has been requested from our order granting the motion for default judgment. So we've, you know, presented all of this to the court, and we hope that the judge can find and order or grant our order granting the default judgment on behalf of plaintiff.
Okay. All right, just give me a moment. I'm just looking over a couple things. Okay. All right, Ms. Valderrama, I do see in reviewing the motion and the court's file that the motion for default judgment has not actually been served on the defendant.
Yes, Your Honor, he did not make an appearance in this matter. And so I don't believe we did mail it to him.
Okay. I think the rules require service, whether a person's in default or not.
Okay.
So here's what I'm going to do. I am going to ask that you file a certificate of service indicating that you are mailing plaintiff's motion for default judgment to the defendant. And if you will file that with the clerk and send a courtesy copy to Ms. Seeger for my review.
Yes.
I'm going to take the case under advisement. If within 10 days there's no further activity on the file, my intent would be to go ahead and grant the default, but I do think they're entitled to get a copy of it before
Yes, Your Honor.
it's entered. And I will just say you filed a notice of hearing.
Yes.
And that also, you know,
Oh,
if you're going to have a hearing, our local rules do require that you give everyone notice. And again, you didn't send the notice of hearing. I understand they're in default, so there's case law out there that says they're not, I don't have to give them notice of a hearing, but I think it's the best practice. The service rule still does apply. So I want you to serve the motion, provide the court with that certificate showing you served the motion, and then I'll intend to rule on this by the end of the month or early August.
and Your Honor, should I guess, should I put a time frame for them to respond? You know, if not responsive by this date, the court might do a default or anything?
No, I don't think you're required to do it. I think the rules say we serve pleadings.
Okay.
There's no exception to the service rule for, oh, well, they defaulted, so we get to stop serving pleadings. So I simply want you to serve it. You don't need to tell them anything else. The citation told them what they should have done. They haven't done it. In all likelihood, they still aren't going to do anything. I'm kind of setting the time period by telling you, I'd like you to accomplish this today.
Yes,
As
we'll
far
do
as the putting it in the mail and providing the court with the proof that you put it in the mail by filing the certificate of service. And I am going to set the time period, which is basically, I'm going to give them about 9 or 10 days. And if there's nothing's done during that time period, it would be my intent to grant the default.
Thank you, Your Honor. And we'll send that first class mail and I'm sorry, CMRR.
Yes,
If
that
I-
works.
Okay.
Yeah, that works. And just make sure you email Ms. Seeger so I know it's been accomplished, and I will make a note to myself to check the file again. And if you haven't already sent in the actual default order, please do that as well.
Okay, and can I email that to Ms. Greer also, or Ms. Seeger, I'm sorry?
Yes, Ms. Seeger is the one who needs to get it.